Termination of employment under labor laws of Nepal. Governing laws. Labor Act 2017 and Labor Regulations 2018 are the primary laws governing the matters related to termination of employment in Nepal. Termination of time-based, work-based, and casual employment. A. Time-based employment. The time-based employment can be terminated upon the end of the term stated in the employment agreement. B. Work-based employment. The employment of an employee engaged on a work-based employment is terminated upon the completion of the work specified in the employment agreement. C. Casual employment. In case of casual employment, the employment can be terminated at the will of the employer or the employee. Voluntary termination of employment. An employee can submit a written notice of voluntary resignation to the employer for the termination of the employment relationship. The employer must acknowledge the employee's resignation within 15 days. If the employer fails to acknowledge it within the specified time, the resignation will be deemed accepted from the day following the end of the given time. The resignation can be cancelled on mutual consent between the employee and the employer. Termination of employment on the ground of incompetency. The employer can terminate the employment relationship if the employee's work performance is found to be unsatisfactory or poor for 3 or more consecutive work performance evaluation. In case of an enterprise employing 10 or more employees, the employer must provide time period of at least 7 days to submit clarification in relation to their work performance prior to such termination. Termination of employment on the ground of misconduct. The employer can terminate an employment of an employee in case such employee is engaged in misconduct, some of which are as follows. A. Engaged in physical assault or causing physical harm to any person related to the employer or customer or workplace. B. Engaged in receiving or granting bribery. C. Committed theft against any person in the workplace. D. Remained absent from the work for more than 30 consecutive days without having leave sanctioned. E. Damaged employer's property maliciously. F. Submitted any fake educational certificate and other certificate for the purpose of appointment. G. Consumed narcotic substance or liquor during the working hours or come to the workplace upon consuming the same. H. Been convicted by the court of any criminal offense involving moral turpitude during the period of employment. Prior to terminating an employee on the ground of misconduct, the employer must provide a time period of 7 days to submit clarification on the matter. Termination of employment on the ground of health. The employer can terminate the employment on the ground of health if any employee becomes incapable to work due to the following reasons. I. If the employee is unable to work as a result of physical or mental incapacitation or grievous hurt or injury. Or II. If an employee requires prolonged medical treatment that affects their work performance. Furthermore, the employer cannot terminate the employment of an employee undergoing treatment for an accident or occupational disease suffered while performing their work until the following time period. In case of treatment at hospital, employment cannot be terminated for the entire period of treatment. Or, in case of treatment at home, employment cannot be terminated till 1 year from the start of treatment. Such employees are entitled to full remuneration from the employer till the aforementioned time period unless the employee receives remuneration from the Social Security Fund for such period. Notice period for termination of employment. Prior to termination of an employment for any reason other than misconduct, both the employer and the employee must provide prior written notice to the other party as follows. Period of employment up to 4 weeks, notice period 1 day. Period of employment 4 weeks to 1 year, notice period 7 days. Period of employment more than 1 year, notice period 30 days. However, for employees in managerial labor, the Labor Act allows for determining the conditions for termination of their service. Retrenchment. An enterprise may retrench its employees in the following circumstances. 1. Where an enterprise faces financial problems in its operation, or 2. Where the number of employees increases due to merger of more than one enterprises, or 3. Where the enterprise needs to be closed down partially or completely because of any other reasons. In case of retrenchment, the employer must pay compensation at the rate of 1 month's basic remuneration for each year of service for employees engaged for more than a year. Similarly, for employees employed for less than a year, such compensation must be paid proportionately. where, for any reason, the retrenchment has been made but the entity resumes its operation within 2 years or needs to supply additional employees, the entity must give preference for employment to the retrenched employees. However, this provision of retrenchment is not applicable to enterprises employing 10 or less than 10 employees. Compulsory retirement. Employees in regular employment are subject to compulsory retirement upon reaching the age of 58 years. However, if the entity has to provide compulsory retirement before 58 years due to the nature of work, such provisions can be included in its bylaws upon obtaining approval of the Central Labour Advisory Council. Post-termination obligations of employer. Upon termination of employment due to misconduct or any other reason, the employer must make payments of remuneration, benefits, and entitlements to the employees within 15 days of such termination. If the employer cannot make such payments within the stipulated time period, they must continue to pay the employees remuneration as if they were still employed until all dues are settled. Further, the employer must provide certificate of work experience stating period of service and post of such employees. Remedies available on termination of employment. In case any employee is not satisfied with the decision of the employer regarding termination of employment, such employee can file an appeal in the labor court against such decision.